Introduction to EU law. EU law can be divided into primary and secondary legislation. The treaties are the basis or the ground rules for all EU actions and fall under the primary legislation category of the EU law. The secondary legislation category of EU law is much broader. It includes regulations, directives, and decisions. These laws are derived from the principles and objectives set out in the treaties. Let's focus on the primary legislation for a moment. The primary law comes mainly from founding treaties, namely the Treaty on the EU and the Treaty on the Functioning of the EU. Both the treaties are normally referred in shorthand as TEU and TFEU. These treaties set out the distribution of competencies between the Union and the member states and establish the powers of the European institutions. They therefore determine the legal framework within which the EU institutions implement European policies. The aims set out in the European Union treaties are achieved by several types of legal acts. The biggest distinction between these legal acts is that some are binding and others are not. Some apply to all EU countries, others to just a few. First one are regulations. A regulation is a binding legislative act. It must be applied in its entirety across the EU. For example, when the EU wanted to protect the names of agricultural products coming from certain areas such as Parma ham, the Council adopted a regulation. The second are directives. A directive is a legislative act that sets out goals that all EU countries must achieve. However, it is up to the individual countries to decide how. This was the case with the Working Time Directive, which stipulates that too much overtime work is illegal. The directive sets out minimum rest periods and a maximum number of working hours, but it is up to each country to devise its own laws on how to implement this. The third types are the decisions. A decision is binding on those to whom it is addressed. It can be an EU country, an individual, or a company. A decision is directly applicable. For example, when the Commission issued a decision fining software giant Microsoft for abusing its dominant market, the decision applied to Microsoft only. Fourth is a recommendation. A recommendation is not binding. To give you an example, when the Commission issued a recommendation that the pay structures for financial sector employees should not encourage excessive risk-taking, it did not have any legal consequences. A recommendation allows the institutions to make their views known and to suggest a line of action without imposing any legal obligation on those to whom it is addressed. Fifth, an opinion is an instrument that allows the institutions to make a statement in a non-binding fashion. In other words, without imposing any legal obligation on those to whom it is addressed. It can be issued by the main institutions, which are the Commission, the Council, and the Parliament. While laws are being made, the committees give opinions from their specific regional or economic and social viewpoint. For example, the Committee of the Regions issued an opinion on the Clean Air Policy Package for Europe.